I'm the executor. What bills do I pay first? First and foremost, congratulations. You have just inherited one of the worst jobs that can ever be bestowed upon you that is often blanketed as an honor. Make sure that when you are starting your journey as the executor, the first thing you're going to do is take all of the bills and set them aside. The only thing you are supposed to pay at this point is going to be bills that are considered secured, meaning they are part of a mortgage. They are a car payment. There is an asset that is attached to this bill, or if the bill is considered a service, electricity, utilities, insurance, something in that line. Everything else, creditors, hospitals, credit cards, student loans, unsecured debts, personal loans, you are going to set those to the side. You are not going to pay them for a while. In New York State, you need to wait 7 months before you can actually sit down and filter through those bills and figure out how many assets do I have? How many bills do I have? Do I have more bills than I have assets? We've got to then only pay out in order of priority. If we have more assets than bills, no problem. This is going to be an issue if you pay bills and distributions ahead of schedule and you are the executor or the administrator and you say, oh, the kids really need the money right now. I don't want to wait until the end of the creditor period, so I'm going to give them the money at the moment. The issue is going to be if there is not enough money by the time you get to the end of the estate, then you personally, out of your own pocket, have to pay the bill, not the difference. The bill. So this is something you need to actually hold very firm on. Beneficiaries are not to receive distributions early. That is going to create a huge problem for you. I will tell you the legend of the young attorney in Otsego County. This is one of the things that was formative for me very early on inside my office. There was a young attorney who is taking over the estate of an elder attorney. The elder attorney was very famous in this county. Everybody loved him. He was absolutely beloved and he was known to be quite wealthy. Had a beautiful home. His wife had multiple horses. He was off to the track. He was out to the casino quite often, probably once a month, if not more. He booked many bus trips for his buddies to be able to go to these places. So when the young attorney was hired to manage the estate, he was excited. This was going to be a lovely bill for him. He was going to be able to manage quite a chunk of money, be able to help with the law office, probably get a good footing, and capitalize on this opportunity. What actually happened was that the young attorney came into the office, sat down, looked at all of the money that was sitting inside the attorney's IOLA, and slowly started paying out to clients very early. Hey, you had $1,000 on the IOLA with this guy. I'll give you your $1,000 back so you can hire a new counsel. Oh, you had $30,000 on IOLA with this guy? We'll give it back. An IOLA is an escrow account. It's money that clients give us that we have to hold and make sure that if they're going to pay us, this is basically the pot that they pay us out of. Well, that young attorney got about 40 clients in before he realized the IOLA didn't balance. The money didn't balance. There was more money owed than what was actually sitting in the bank accounts. And when he went through the personal status of that particular attorney, it was the same thing. He had been debt leveraging. He was living on margins. While he had given out this huge appearance of being incredibly wealthy, his bank account was not in that category. And in the meantime, this poor young attorney had already paid many of those things. So what happened to this poor guy? He got in trouble. He ended up having to personally pay many of the clients that had already had their money stolen by the elder attorney. This attorney had to foot his own bill in. It set him back financially in his practice significantly. He ended up having to pay fees to these people, interest to these people, because he made those original payments, and he never should have done that without having the accounting first. He needed to sit down and have figured out, how many assets do I have? How many bills do I have? Not just assume that this guy who put on the air of being rich was actually rich. You can look rich and not be rich. They are two completely different things. So the legend of the young attorney is something that has been handed around the county to all of us who have come in afterwards, because the judges in the county were horrified by this. They were incredibly upset when it happened because they felt bad for this young guy starting out his practice. Now, this all happened about 40 years ago, and I had this legend told to me when I entered into the practice. So it's something that I want to put out to you. If you're new in this business, or if you're new being an executor, or you're new being an attorney, do not just assume because somebody appeared to be wealthy that they have the funds to cover all of the debts that they had. Many people, even in that upper echelon, use debt to be able to give off that appearance, and those debts will need to be paid. You want to wait, make sure you have the true accounting, make sure that this is actually solvent. If it is solvent, once you know and you've gone beyond the creditor time period, then yes, payout. I hope this helps. If you need some assistance and advice, I don't just talk about this on the internet. I do this in real life. Make sure that you book a call. You can book a consult with me, and I will talk to you about your New York estate and exactly what you need to do to help you get it opened, done, and settled. Thank you so much. I'm Lauren Glynn. It's been a pleasure to talk to you. Like, share, comment. Let us know if you have questions. Again, if you want personalized advice, give us a call.